All right, our first panel is going to be an interesting panel. I think to start the day off, we're going to get pretty fundamental. We're going to talk about Texas water law, a subject that's very deep, I must say. I'm going to go ahead, and we've got a great panel today of folks that have worked in the legislature on key issues, as well as lawyers who have worked in the real world and have applied and understand the impact of the laws that we pass in the legislature or our Supreme Court determines to be the case in the state of Texas. So let's first introduce our first panelist, State Representative Allan Ritter. Allan, come on up. Allan was first elected to the Texas House of Representatives in 1998. He represents District 21, which includes all or parts of Jefferson County and Orange County, which is a little bit of a drive from out here in West Texas. We appreciate him being here. Allan currently chairs the House Natural Resources Committee and serves on the Ways and Means and Calendars Committee. So these are key committees for Texas. And chairing the House Natural Resource Committee was key last session in the passage of Senate Bill 332. He is a native of Southeast Texas and is the president of the R Brothers Limited, his family's 60-year-old business, which operates a Ritter at Home. This is an internet site, Ritter at Home and Ritter Forest Products retail stores in Texas and Louisiana. Let's welcome Allan Ritter. Allan. Our next panelist is State Representative Doug Miller. Doug is a state representative from District 73. He was appointed by Speaker Strauss as a member of the House Committee on Appropriations, Natural Resources, and previously served on House Administration, all key committees that affect everything you do in the Texas legislature. Representative Miller holds the rank of a major in the Texas State Guard. He served as mayor and council member of the New Braunfels and as a member of the Regional State Water Planning Group, and most recently as chairman of the Edwards Aquifer Authority. That's also known as EAA, or DAY versus EAA. We'll hear a little bit about that today. As former chairman of the board of the Edwards Aquifer Authority, Doug worked with the legislature to help write Senate Bill 1477, which created the Edwards Aquifer Authority in statute. He was one of the original members of the EAA board and was its longest-serving member. He also worked with Senator Buster Brown in writing Senate Bill 1 in 1997, which created a new bottom-up model for Texas water planning. And that's one of the, I guess, probably nationally, probably one of the most foremost pieces of legislation with regard to statewide water planning. By the way, I just saw former Senator Kip Averitt out in the audience. Kip, stand up and raise your hand. Kip was former chairman of the Natural Resources Committee in the Texas Senate and played a major role in doing some things with us. So, again, it's really a pleasure to have Doug here because Doug has been at the forefront of water planning and also can give us some information about the Edwards Aquifer Authority, which I think is applicable to all of our debates in water law today. Tom Massey. Tom, come on up. Tom Massey, of course, is an attorney and a former member of an esteemed member of the Texas House of Representatives. As Drew said a while ago, during his tenure in the legislature, Tom chaired the House Committee on Calendars and the House Committee on Education, and those are two powerful committees. Calendars, the chairman of Calendars determines what bills go to the floor, probably the most powerful single chairmanship in the Texas House. After the legislative service, he worked as a special consultant to the Speaker of the House. At that time, I believe it was Billy Clayton, on the water matters, and went on to serve as a member of the High Plains Study Council, the Western States Water Conference, and on Governor Clement's Water Task Force. So he has a vast knowledge of the history of Texas water law and how it's developed in the state of Texas. And finally, Mark McLaughlin, who's everyone in this room probably knows very well. Mark is a rancher, a local businessman, and a lawyer who grew up near Snyder, Texas. He graduated from the University of Texas with degrees in both business and law, and has served 2 years in the Air Force as a trial and defense counsel in court-martial cases during the Korean War. In 1963, Mark and his family moved to San Angelo, where he and a former law school classmate formed the Texas State Bank. It was during that time that he purchased the first acreage of what would become the Double M Ranch. Mark has a reputation as a highly successful attorney and someone who's had a remarkable impact on the community. Statewide, Mark has served as both president of the Texas and Southwestern Cattle Raisers Association, by the way, which was an organization that was instrumental in passing the water ownership bill last session, and vice president of the State Bar of Texas. I think he's also an esteemed or a distinguished alumni for that university in Austin called the University of Texas. So. Ed Small will not be here today, but Ed is an attorney in Austin, Texas. Was Small Craig. It used to be Small Craig and Working Team. Now it's Jackson Walker, and is an expert on eminent domain. But I think our panel today we have a panel with a broad array of knowledge, and I'm happy about Mark being on here because he's a rancher and he can really talk to us about the importance of property rights with regard to our ranching. So the way we're going to do this today is I'm going to just start asking some questions and try to build a background, and we'll get a dialogue from the panel. I'll specifically address in the beginning questions to the panel members toward their expertise, and then we will allow them to dialogue. They can talk among each other. You can feel free to, you don't have to be recognized by me to pick up your mic and say he's wrong, he's right. The purpose here is to give have a practical discussion about some of the changes in law in Texas and water planning and water rights and things like that, how they impact Texas and how they impact you. So my first question will go to Allan Ritter. Allan is one of the House sponsor of Senate Bill 332. And that's the number. I never can remember these numbers, but as chairman of the committee, how do you believe that law has impacted the state of Texas, and has it really clarified the issue of ownership of groundwater?
Well, Senator, at this time, can you hear me? Okay, at this time, I think it has made a giant leap as to clarification. I think the courts actually kind of followed what we did with 332, making it very clear that water under your property is a right of that landowner. But to what degree and where it becomes that right is in question as to whether you're in a groundwater conservation district or whether you're not. And it appears to me that the courts ruled pretty much in the direction that we went with 332. And thanks to a lot of your leadership and such, because we worked on it for many hours in that last legislative session, but I believe we're going the right direction. I believe it answered so much as that landowners do have a right.
Just a follow-up question on that. Whenever that bill was passed, was it supported by different groups that were really advocates for the ownership of, for at least defining what the ownership was? What organizations were it?
Farm Bureau, Texas Southwest Cattlemen Association, Wildlife Association. I can't think of one that wasn't on board with it.
It seemed like it was all of the different organizations that represent agriculture as well as those that represent the environmental
agriculture, property owners supported. And this was a bill, actually this one had kind of been in the works for several years. And you know, I always make this statement, Senator, that Natural Resources Committee and water itself is a very, very slow moving animal, that it takes a long time for us to for things to go through its cycles and for legislation to happen and for us in the real world to see something actually be finalized and accomplished. And this bill is no different. I can remember when Senator Averitt was chairing Natural Resources in the Senate. This was an issue then, and we've been debating it ever, since way back. But this is a major step. It's a good piece of legislation. Now, will there possibly in time be some tweaks to it? Right now, I can't tell you that our committee has anything in the pipe that we're ready to change in legislation. We do have several lawsuits still in action that we'll see how the courts go, how the courts rule, and how they really are finalized, and what actions are taken, and see where we need to make any changes, at all.
That's probably a good segue into the next question, because I think, as everyone in the audience knows, and if you don't, we'll kind of bring you up to speed. The Texas legislature passed a bill last session, Senate Bill 332, that basically declared that the landowner has an ownership interest, a vested ownership interest in the water beneath the ground, subject to the rules of the groundwater district, subject to the rule of capture. And so that was a major step forward. A few months later, and we kept wanting the Supreme Court to come out during the session, but they didn't. But they came out in a case called Day versus Edwards Aquifer Authority, and basically declared that the landowner has a vested property interest in the water under his ground, which not only did the legislation that we passed answer that question, but also did the court in their decision in Day, and they basically followed the lead of the legislature in passing Senate Bill 332. So what they did in that case, and I'm going to ask Doug some questions since he's our Edwards Aquifer Authority expert in the legislature, is that they basically told the Edwards Aquifer Authority, says, okay, you have established a regulation that deprives this man of his water, and he has a property right to that water, so we're going to send it back to the trial court, and we're going to have the trial court determine whether or not that's a takings under the Texas Constitution, and whether or not that landowner is entitled to compensation, and if so, how much. Doug, what's your reaction to that?
Well, thank you, Senator.
It's an easy question.
Easy question. Yeah, it's just the Edwards, right, Mr. Chairman?
Just the Edwards.
I see Russ Johnson came in. He wants to hear the answer for this, because Russ and I sat across the table from each other in Governor Bullock's office while we worked through this legislation back in '93. Senator, I think that what the court said, and I'm not an attorney, and some people claim I'm an expert, but I'm just an insurance agent that got thrown in the middle of a war to try to save its community. And I know we've got Larry and Phil and a lot of people from San Marcos that were very interested in this, because the life of our communities were dependent upon what happened in the Edwards Aquifer, as well as San Antonio and a lot of others. So what I think the court said in that case is that they still upheld that the constitutional amendment that was passed by the people in 1919, where it allowed the legislature to regulate its natural resources, including water, still exists. And that's still the law today. You and your chamber and our chamber have a responsibility, not only, I guess maybe a right in constitutional law, but a responsibility to protect the people. And that's protect all the people. What the Dan McDaniel case did say was that you can't do what the legislature told you to do in SB 1477 back in 1993. Statutorily, the Edwards Aquifer Authority was told that you would use, and this was through negotiations, that we would manage the aquifer, and it would be based upon a person's historical pumpage, their historical usage, and they would have a time. There would be actually a 19 to 21 year time frame when people, if they pumped during that time, and they would submit an application for a right to withdraw, that they'd be given a permit to withdraw that water, to use that water, to sell that water, whatever they wanted to do with the water. But it was all based upon that historic usage. And so that's the whole premise that we move forward with, In 1993, after the legislation, I was appointed by my commissioner's court and city council to go serve on the Edwards. And then in 1995, no good deed goes unpunished. Senator Armbruster, who was the sponsor of the legislation, said, "You said it would do this, now you go on down there and make sure it does it." So we operated for 16 years. I served on that board, the last 5 as chairman. We operated under the premise that we were being directed by the legislature to issue these permits, to somehow manage this resource where one community or another, whether it be the agricultural interest or the city of San Antonio or the Springs interest, wasn't able to, use more water than they needed or take an inappropriate amount. Now, the case said, again, you cannot use, basically this is where they overturned the legislature is, you can't use historic uses as the sole reason for issuing groundwater permits. That if you use a whole bunch of other factors, which, I met some folks last night, I think Jim from over in Sonora and other folks that have groundwater districts. That is the preferred method that the legislature has set forth to say, we want you to manage your water on a local basis. And the way we'll do it is through local groundwater districts, because you have the right to elect people to those boards, and if you don't like those people, you throw them off and you put some new people on there. So it's a local measurement, and that it can all come together to manage our resources. But those groundwater conservation districts use a lot of measures. Well spacing is one of them, other measures. But the court, in my opinion, said you just can't use as a sole instrument for issuing those permits historic use.
Okay, Tom, Massey, do you believe that the Edwards Aquifer Authority case deals with property rights and deals with, you're familiar with both the day and the Senate Bill 332. How do those bills, how does that bill and how does what happened in the Edwards Aquifer Authority and the day decision, how does all that add up for those of us in the real world?
Well, Senator, what I think they both do, 332 and the day opinion, tighten up the ownership. Now, 332 deals with Section 36 in the Water Code, which used to be 52, Chapter 52, and it's always said, or so long as I can remember, that nothing is going to disrupt or mess with ownership. But in my opinion, 332 really tightened that up, really did. And the day opinion gives pause for a lot of water districts to consider, how they're going to handle that. Yes, I think they both affected and property rights.
Mark is a rancher and a lawyer and a former vice president of the Texas and Southwestern Cattle Raisers Association. Give us your take on from the rancher's perspective, legally, how do you believe the day opinion and Senate Bill 332 interact to protect groundwater rights of ranchers and farmers?
Well, let me say, I'll speak from a rancher's viewpoint. You got to have water. If you don't have water, you're out of business, and that land is worth nothing. You don't have any livestock. You don't have anything to sell. So it's critical and very essential. You can haul hay in, but you'll go broke hauling water in, I'll guarantee you. You just can't do it. So the ownership of water is very important for the use of the ranching landowner. When I first went to public school, a long way back, years and centuries ago, there were 6 million people in the state of Texas. Today, there are 25 million that they can count. They're not too sure how many extra beyond that number there are. we have the same amount of water. We have cities, great urban areas that consuming huge amounts of water. And this situation of the finite supply of water and the enlarging population is going to lead into inevitable conflicts. I think the Texas legislature has done an excellent job. I thought Bob Bullock's Senate Bill 1, when he talked about local regulation of water, was exactly the right solution, and I'm very happy with that. Where my property is located, we have an underground water conservation district. We do elect representatives who sit on that board who do talk about issuing permits for withdrawal. The legislative plan was that any landowner is entitled to a minimum amount of water for household and livestock use. That's good. But beyond that minimum amount, you must get you must have a regulated withdrawal to avoid under what's called the rule of capture, where I can dig a hole and withdraw water, my neighbor can dig a hole and withdraw water, and as long as we don't do that wastefully or maliciously, we each have the right to withdraw water. However, in this age, and you know, oil well fracking has become a great topic of conversation. I heard it on the radio this morning about people in Pennsylvania complaining about fracking and saying it had affected groundwater, which I think that's a bunch of baloney, but.
Do you have an opinion on that, Mark?
Yes.
I share his opinion.
But anyway, I do know in my area, for instance, they're drilling a horizontal well that'll have a horizontal leg over a mile long. They're going to have to frack that. They're looking for water. I do know it takes over 1 million gallons of water used to frack a well. Now, some of that's recovered. Naturally, it flows back, but a lot of it's lost. There are people who have small tracts of land who want to sell that water. And consequently, they'd like a big bore well and a because I'm dependent on that water, as I say. Fortunately, we have the district, the Underground Water Conservation District, that can regulate the amount of withdrawal. And
well,
to me, that's the perfect solution. Local control over withdrawal and reasonable for the circumstances.
how much time do we have left? 20 minutes? Okay, good. We got plenty of time. Doug, you wanted to,
Let me just
respond to that.
And Mr. McLaughlin, you're absolutely right. Senator, you asked Chairman Ritter who were some of the supported groups, and I was probably one of the holdout people that got some of those groups like Farm Bureau and others mad at me because I was concerned about what his point was, that there are people out there. I mean, I think everybody should have the right to have water to take care of their family, their domestic uses, whatever it is for their livelihood. But there are other people that come in there that want to take that water and sell it off. You buy an acre of land and suck out the water from underneath all your neighbors, and then your neighbors are dry, just like Mr. McLaughlin said. And what I found is in the Farm Bureau policy that was passed right before the session at their annual convention was that exact statement, that people should have enough water to supply their own needs and take care of their livestock and their cattle. And that was the point that I made to Farm Bureau and a lot of other groups was, I can support that. I can't support a situation where somebody's coming along and going to dry up his neighbors, and then they can't farm anymore. They can't even have a house because, well, you can't live in a house if it doesn't have water in it. So I think the end result was good, and what we've got is a system. Now, is it perfect? No. And does it need tweaking? Like Chairman Ritter said, yes. But that's going to be the process because we went from 6 million to 26 million, and we're going to probably 40 million. Yeah. 25.
Well, let me have a little segue here then. Let's stir it up a little bit. And because no law is perfect. And if anybody thinks the legislature is perfect, we have a psychologist somewhere around here. Or just come down and watch. Follow us around today. We have a system now, and I like to say on groundwater districts, not including the EAA, but basically the locally elected groundwater districts that are in West Texas and other areas of the state, down in the Eagle Ford area, up in the High Plains one, and different ones. And basically these water districts, in my view, are locally elected folks that are tasked with the role of balancing competing interests to water. And I think everyone agreed that's kind of one of the roles it is. And of course, we have owners. We've imposed a clear ownership right into that. Yet at the same time, in the statutes, we still have exemptions. We have exemptions for certain cities. We have exemptions for oil companies. So the question is do we, where are we going with these exemptions? Do these exemptions cause some issues with regard to the reasonableness of regulations and of groundwater districts? Do these exemptions cause an imbalance in the conservation efforts that the Constitution requires the legislature to perform? Mark, do you want to react to that, or?
Well, I don't have a lot of knowledge of those exemptions. I've never seen much practical application of it. Talking about the Edwards versus the Day opinion, I thought that was crystallized exactly what it ought to be. The Supreme Court said you do not own every molecule of water under your property, but you do have an ownership right in water. You can't say that you have a definite amount, but you have the ownership there and no one can take it from you. It is all subject to regulation in the amount of withdrawal you have and that your neighbors has, which makes a compatible community. I don't worry about I haven't seen the exemptions yet, but as we talked about the increasing population, that fresh water is going to be a real issue in the future.
You want me to try to answer that?
Whoever wants to, I just throw that one out to kind of stir it up a little bit.
There are exemptions and certain exemptions, and there's not, I don't remember, but very few exemptions related to cities, mostly not too far from here. And those were probably done politically some time back, and what my belief is, and I believe our committee's belief is, we don't want to make decisions regarding being politically made. We want to make decisions that are common sense, scientifically sound, and are taking Texas in the right direction. Now, some of the other exemptions for what we basically have found out is when you put all the amount of water, it's not a killer, so to speak. And it is like when each entity is developing their DFCs and such, just like fracking, they're able to get a pretty good estimate in it, where when they're developing DFCs, when they're doing their management plan, they can know that this much is going to be for this exemption, that, and such. And look, this is water. This is about aquifers, and this is about river basins. This is an asset. Water's an asset that we can manage if we use our heads. Now, we can't control what the good Lord gives us in rain, which is our feedstocks, so to speak, but we can do the very best that we can to manage it. I still go back to, Senator, that I hope the legislature, and I think we've done a pretty good job since I've been there, I hope the legislature is about making decisions that aren't political, whether it's the governor or anybody else, making deals for them. It's about sound science, it's about common sense, and it's about management of either those aquifers or those river basins.
Tom, do you want to comment on that?
Well, that's You know, I agree with you. I'm just not sure that it happens that way.
I did say that's our goal.
Yeah.
Very good. Doug, you want to comment on that?
Well, the only thing I'd say, and this is to keep in mind, all politics aside, and I agree with the chairman, is that it is a great, and it was either Representative Massey or Mr. McLaughlin said, it's a balancing act. We've got a challenge in this state with not only the number of people that we now have in it, but also the competing interests, whether it be oil and gas or ranching or irrigation. You think of a situation, and let me just kind of come back to the Edwards because I'm most familiar with it, is that in Medina and Uvalde County until the late 40s, there wasn't an irrigation well down there. They were not irrigating crops. They were dry land farming like everybody else. And then all of a sudden somebody hit the mother lode and said, whoa, what a deal here. And I can produce these crops, whether it's cotton or corn or hay, and I can make money at it. And so that first guy, that wasn't harmful. There was just a little bit of water, maybe a couple of thousand or a couple of 100 acre feet. But then the next one and the next one and the next one. And then they figured out in that situation too that our good friends up in San Antonio wanted that water. And they said, well, you know what? I can make more money selling that water to San Antonio than I can, and I'll just go back to dry land farming. So, again, I point those kind of things out. And those situations, those are just two examples that happen over and over and over again, and we see it. We saw it out here in West Texas. I don't think it was this last session, but I know that Dean Craddock had a bill that he brought in for a pipeline, and we've seen it up in the Lubbock area where folks have drilled water fields and then supplied the city of Lubbock. I'm not saying anything's right or wrong. I'm just saying it's a balancing act. And with all these competing interests, it's a real challenge. So that we're trying to say you've got a vested right in that water. We want you to have that water, especially for your own life and for your own well-being. But at the same time, we've got to allow some type of regulation. We're trying to do it on a local level so that you have some protection too in the law, because that's important that we protect you from these people who want to use the same water you want to use.
I think a statement was made earlier that's really important, is that Texas, let's see, in the 2000 census we were 20 million. In the 2010 census we were 25 million. And of course, our demands for our different industries using water, both our oil and gas as well as our agriculture, is not going down. It's increasing as well. So there's a huge balance that we have in our economy that we're going to have to be able to deal with. Now, we have, about 10 minutes left?
Yeah, you got at least that much. You have some questions.
That's what I was hoping. And
we've got speakers. The acoustics are not real good in here. We have speakers here in either aisle. Feel free to come up and ask the honorable senator whatever questions you'd like.
Okay, and when you come up, be clear and make your question short so that we have time to answer it, and just identify who you are and who you represent, basically. Yes, sir.
I'm Commissioner Precinct 1, Snyder, Texas. It's Great County.
Great county.
And I certainly agree with Mark that fracking is a bunch of baloney as far as harming our water resources. At the same time, I know that according to experts in the Eagle Ford Shale down here in Texas, in the southern part of the state, that it takes 5 million gallons of water to do a frack job there in that particular region. What I'm interested in is if any of you understand or know anything about the gel frack that uses propane, liquid propane, which is totally waterless. They use liquid LPG that goes into the well, carries the sand in just like water does, but there's no cleanup because whenever it returns, it comes back as a vapor. And we're all about economic development in our state, and so if we do know about it, are we pushing it? Because I know down in San Antonio, they are already hiring people to get this started.
Is your committee aren't y'all doing some interim studies on fracking, or is anybody in the House?
Us and Energy's really doing the bulk of that. Our ties with the water.
Well, who wants to answer that question?
Well, we've had some.
Go ahead.
We've had some feedback, as Chairman Ritter said, and I know of some instances where, yes, the procedure that you talked about with propane, now they say, well, it's more expensive, or it cuts down the amount of money we're able to make. Also, we've also heard, I heard just recently, I had somebody in my office, that instead of 5 million gallons, they can frack a well with 500 gallons. And so there's technology that's being developed that I think that part of Chairman Ritter and Chairman Keffer's committees have been trying to encourage and push people along, the drillers along, and the oil companies to be more conservation minded.
Yeah. It depends what shale play it is geographically. You know, one side can be different from the other. We want to learn and know about every method of doing it, fracking and such. But you know, we don't want to be the one that comes out and says, "Here by state law, you got to do this." Markets need to be the markets, and what's going on in East Texas, where I live, is totally different. There's a lot of things we've been learning, like in Canada. And Canada, actually, who's been doing fracking as long as we have in the United States, and been very successful. And I haven't been up there, but they're telling us that they put 100% of their water back underground, totally pure. These things are what we're looking at, what we're interested in. But you're going to see so many new inventions and innovation and technology with fracking. And like Representative Miller was saying, we are aware that there is actually testing in the field of a process, that they claim only uses 500 gallons of water, and they take it with them. They bring it and they take it with them. That's interesting. That would be a great water save. Well, what's going to be interesting is down in the South Texas play, most of those ranchers are making the oil companies drill the wells on their property for two reasons. One, so they can have the water well, and two, so they can charge them for the water they're using. So the markets are the markets. But any innovation that is better, I'm all for it, and I hope it takes off in the market.
I just say economics is going to take charge of that. But I would say I wish they'd utilize JIP water. I was raised out by Knapp in Scurry County, and we had JIP water. And if they would inject JIP water in those wells and it had the same effect as it does on the human body, it would certainly increase production.
What effect is that?
That's great.
Best answer of the day.
Thank you. More JIP water, okay.
Kelly, do you have a question?
Yes, sir. In regard to the Farm Bureau...
Identify yourself and who you represent.
My name is Kelly Stumbaugh. I'm with the Texas Association of Realtors, the West Texas Field Rep, also here with San Angelo Association. In regard to the Farm Bureau policy or the law in and of itself, is there a criteria or a formula in place that says what is enough for a family and the livestock? Because what might be, I think, enough for my family and livestock might be different than someone else's opinion.
I think there is
It's
a
actually in
I
statute.
think the minimum under the law is 2,500 gallons per day.
Yeah,
That's right.
and you got to have so many
Can't
acres to
regulate.
qualify and such.
Okay, thank you.
I don't remember what it is, 10 acres or so.
Okay, any other questions? How much time we have left? A couple of minutes. Okay, well, I think we're ready to wrap up. Let me ask just if any, Tom, I wanted to see if anybody had anything they wanted to add.
I just want to say that, you know, we had the Adjudication Act back in the mid-1960s, and they had a historical period there. It was a 5-year period. And I just think that the today case, I don't know how that's all going to work out. But certainly it's reasonable to have Doug, I agree with you, reasonable to have a traditional, a historical area.
Yeah, let me say something.
Go ahead.
In that case, what the court said, they didn't throw out historical use. They said you can't have historical use 100%.
Yeah.
So they're going to have a hybrid kind of plan that isn't uncommon with groundwater districts in the state of Texas. It's done. It can be done. They're going to have to jump through a hoop, so to speak, because it's totally different. But Doug's right. The legislation did mandate that they do historical use. The courts turned that over and said, well, you can't do just totally historical use. I think it's achievable.
Mark?
I'd like to add one other thing. In the Nolan County Water Conservation District, we have monitor wells, and they monitor the level in the aquifer. And when there is a reduction in the level, there is a proportionate reduction from all permitted uses. And I think that's a wonderful
It's
solution.
good management.
That's reasonable.
Well, as we work through, and of course, water law in Texas is evolving. I think you can now maybe go to the oil and gas law and figure a little bit of it out after the day decision and after 332. But again, it's evolving, an evolving area. But it seems like Texas is on the right path. But Texans are going to have to be patient with us until we get it right, because I know the effort from the policy perspective is to get it right, and that is to balance the competing interest to the groundwater in the state of Texas. We hadn't even talked about surface water, which is totally different. But groundwater, again, especially in this part of the world, as you drove out to Cristobal last night, you saw some beautiful cotton. And that wouldn't have been here on dry land, and it's very important to this region. Tom?
Senator, as you and I talked earlier, there's got to be some reconciliation one of these days, maybe not in our lifetime, between groundwater and surface water. I know that the states out west of here think we're ridiculous because it's all one system, and we know it's all one system, but we work it under two laws, which doesn't really make that much sense when you're talking about the long haul and conservation of water.
And that's those decisions were made a long time ago, and you're very astute that when we grow to 30, 40 million people or whatever it is, these policy decisions are just going to have to continue to evolve to meet that demand and to continue to balance fairly the competing interests. Now we know you have a property interest, a vested property interest. And I think that's going to make a big difference in the way we move forward in Texas. Thank you very much. Let's give our panel a big hand.